13, it deals with trials and juries. Learning objectives. We're going to trace the history of trial by jury, analyze the scope of the trial, of the right to a trial by jury in a criminal case, evaluate the impact of differences in jury size and unanimity requirements, explain how a jury is summoned and selected, including the constitutional limitations on those processes, discuss the function of jury consultants in the process of scientific jury selection, distinguish between the presumption that apply at the start of trials and the burdens of proof applicable to overcoming them. Summarize the basic rules of evidence concerning trustworthiness and relevance of evidence. Analyze how special limitations on expert witnesses affect the litigation of criminal cases, especially with regard to leading types of forensic evidence. Identify the steps in a criminal trial. Describe the effects and implications of pre-trial publicity and the solutions that courts use to prevent those effects from influencing a criminal trial. The history of trials by jury, it has its roots to the English system under the Magna Carta of 1215. Colonial development. The document was transferred from Britain to colonies and written in the Constitution, Article 3, Section 2. Then we look at the 6th Amendment, the 7th Amendment also. Laws on the book, the trial constitution and the constitution and trial by jury. Jury size. Size of the jury is fixed at 12 by historical accident, not required by the Constitution. 6-person jury accepted in non-capital cases, in other words, in homicide cases. Less than 6-person jury have been struck down. Evidence suggests few differences in deliberations between 12 and 6-person jury. Unanimity. Unanimity required since the 14th century. In 1970, Supreme Court held that federal criminal trials must be unanimous. In other words, all the 12 juries have to vote guilty together. State verdicts of 9-3 and 10-2 have been upheld. Research shows unanimous jury tends to be hung less often. In other words, they reach decision most of the time, deliberate less thoroughly, and result in more satisfied jurors. Laws on the book, selecting a fair and unbiased jury. Each county keep a master jury list. So they get them from voter registration lists. The advantages is they are readily available, frequently updated, collected in district within judicial boundaries. What are the advantages? Most of the time exclude poor, young minorities, and the less educated ones. Some also uses telephone directories, utility company lists to compile a list of a master jury list, and they also use driver license lists to get the names of the people they needed. Jury panels can be challenged if they fail to include racial or other minorities. Requirement of representative cross-section of the community applies only to jury pools, not to juries choosing from the pool. Veneer is what we call the jury pool. It's a random selection from the master list. Not all persons choosing will serve on the veneer. Most states have requirements. Statutory exemptions may exclude others. Random selection from the veneer. And after then, they issue a summons to the individual to appear for a jury selection. Alternate jurors. These are regular jurors, may be excused through process, overall satisfaction for serving on jury, focus on reducing inconvenience of jury duty, and statistically, 1/3 of Americans will serve on a jury. Educated jurors, a chance to meet the jury. Jury's consultant, they use questions designed to uncover hidden biases, develop a profile of jurors, hired mostly by defense attorneys. They could deselect jurors not favorable to the defendants. Presumptions and the burden of proof. Presumption of sanity. All defendants are presumed sane unless evidence of insanity exists. Presumption of innocence. The defendant is not required to prove him or herself innocent. Burden of proof, burden of production, burden of persuasion, and reasonable doubt. Type of overview of basic evidence. Types of evidence. Real evidence. Objects of any kind. Then we have testimony. These are statements by competent witnesses. Then we have direct evidence. These are eyewitness evidence. And then we also have circumstantial evidence, meaning indirect evidence, scientific evidence, such as DNA and forensic investigation, and demonstrative evidence, no evidential value. These are evidence with no evidential value by itself. Okay, rules of evidence is based on trustworthiness, best evidence rule. Hearsay, generally not admissible. It must be relevant, must be a valid reason for introducing the statement, object, or testimony. Scientific evidence, the general acceptance test. It happens in the case of Fry versus USDC, in other words, United States District Court for the District of Columbia, 1923. Relevant and reliable. Objects to the admission of evidence. Evidence is irrelevant. Objections to the admission of evidence. If the evidence is irrelevant, immaterial, and hearsay. And then we look at cyber conference and mistrial. Reasonable doubt. Defense does not have to call witnesses. Defense does not have to introduce evidence. Undermine the state's case through cross-examination. Forcing the state to prove its case is thought to be the weakest kind of defense. Special rule of evidence governing expert witnesses can be found in the Federal Rule of Evidence 702. Determine reliability. Forensic science evidence in the age of Dobat, flood, firearms, fingerprints, junk science, and CSI effect. Objections to admission of evidence has to be timely objections and can lead to mistrial and challenging forensic science. Steps in the trial process. We have the opening statements. Prosecutors are case in chief. They direct examination and they also do indirect examination. They could motion for judgment of acquittal. So also is the defense. The defendant as witness. Fifth Amendment protection against self-incrimination is applicable. Defense attorney must consider whether the defendant's story is believable. Defendants who take the stance are subject to cross-examination by the prosecutor. Their story, they could face impeachment of credibility, and renewed motion for judgment of acquittal could also occur. Alibi defense. Somewhere else when the crime was committed. In other words, they was somewhere when the crime was occurred and they have a witness to that. Affirmative defense. It's a legal excuses that should result in finding of not guilty, such as self-defense, duress, in other words, under force or threat, entrapment, and insanity defense. Challenging scientific evidence. It could be challenged through the way the evidence was gathered, preserved, and analyzed. Prosecution rebuttal. They could discredit testimony of a witness or discredit the witness himself or herself. Previous convictions of defendants who take the stance will come into play. Closing arguments. Prosecutors, they try to tie up the facts, argue for verdict of guilty. The defense attorney tried to highlight evidence favorable to the defendant, criticizes the state's witnesses, calls upon jurors to return a not guilty verdict. With prosecutor, the burden of proof allows prosecutor last say. Jury instruction. General legal instruction specific to the case, possible verdict that the judge will tell the jurors, and charging conferences. What motivates a jury during a jury deliberation? Juries usually vote as soon as they retire to the jury room. 90% of the time, the original majority wins. Then we're going to look at Allen charge, and hung juries are very rare. Hung juries are very rare. Correction. Are juries biased? That's the question. The verdict in federal court, non-drug cases in juries convict 82% of the time. In state court, juries convict 2/3 of the time in criminal cases. In other words, almost 66% or 67%. Judges versus juries. Juries convict felons more than judges. Judges convict non-felons more than juries. Acquittal. That ends the case and the defendant goes on. In a guilty case, the defendant or the defense attorney can motion for a new trial, mostly a formality. Few new trials are ever or retrial are ever granted. Trials as balancing wheels. Popular standards of justice. Major reason for disagreement between jury and a judge. We look at jury legislation and jury nullification. Uncertainty. Plea bargaining reduces the uncertainty of lay citizens involved in deciding legal matters. Few criminal trials involve publicity. Pre-trial publicity does affect juries. Research has shown. And then we look at voir dire, the jury selection process. Techniques for reconciling a fair trial and freedom of the press, such as limited gag order, where the cases cannot be discussed publicly, change of venue, in other words, where they could move the trial to another city or another location for trial, sequestering the jury, where the judge might order them to stay in the hotel and not watch TV, media in the courtroom, if the judge wants to allow TV personnel to record the trial, misuse of technology, and media distortion of the case. Ladies and gentlemen, that's the end of chapter 13. We will start chapter 14 of your book in a few seconds. This is also going to be a short PowerPoint lecture. Chapter 14, it deals with sentencing options, learning objectives, distinguish between the 5 major sentencing philosophies, describe how the 3 branches of government are involved in sentencing, list all major 4 issues related to imprisonment as a sentence in the United States, identify the 3 major alternatives to imprisonment, summarize the 2 Supreme Court rulings from the 1970s on capital punishment that led to the bifurcated process of death penalty sentencing, indicate how the court has narrowed the list of death eligible cases and offenders, discuss the major differences between the due process model of criminal justice and the crime control model, of justice with regards to death penalty. Retribution. It holds individuals responsible for their action. Let's look at lex talionis, just desert, proportionality, and expiation. Deterrence. Why do we sentence people? Part of the reason we sentence people is deterrence. In other words, prevention of future crimes. We look at hedonistic calculus, general deterrence, specific deterrence. Punishment should fit the criminal. In other words, severity of the punishment for the crime committed, certainty, and celerity of punishment. Utilitarian. Research done by Bentham. It rests on the assumption of rational behavior. Under why do we sentence people again? We look at rehabilitation. Rehabilitation, treat rather than punish, such as probation, parole, pre-trial diversion, such as attending Alcohol Anonymous or drug rehab, evidence-based corrections, public safety realignment, and sentences should fit the offender rather than the offense. Incapacitation assumes crime prevention, is also future-oriented. It focuses on personal characteristics of offenders, and its limitation, no standards for length of sentence, lack of focus on reform may result in worse situation behavior. Imprisonment is temporary solution. Selective incapacitation. Restoration. It seeks to replace retribution. Crime is conflict between individuals. Crime is secondarily a violation of government laws. The principal aim of criminal justice system should repair these injuries. Criminal justice system should facilitate involvement of involvement of victims, offenders, and community. There are three elements to restorative justice. Crime is primarily a conflict between individuals, which result in injury, like I said earlier. Principal aim of the criminal justice system should be to repair these injuries. The criminal justice system should facilitate the involvement of victims, offenders, and community. Should restorative justice replace revenge-based sentencing? No. Could argue for that. Who should decide sentence? Sentencing responsibility lies with the legislative aspect of each state and the federal government. Executive, judicial, parole boards create sentencing options under the criminal codes, indeterminate sentence, and determinate sentence. Judicial sentencing responsibility. Under the sentencing option, we have the rehabilitative model with a wide discretion. Due process model, they look at discretion as inequity. The crime control model looks at the rehabilitative system as too lenient. Who should decide the sentence again? Executive sentence responsibility lies with individual state governors or the President of the United States, parole boards at the state level, departments of corrections. Carrying out sentencing, the parole, good time for credit for good behavior in the prison, and pardon. Cruel and unusual punishment is analyzed under the 8th Amendment of the United States Constitution. Imprisonment. Nowadays we have prison overcrowding, conditions of confinement lawsuit where states are being sued for bad condition in their prison system and the high cost of maintaining offenders in the prison, realities of imprisoning large numbers of criminals is forcing states to look at alternative sanctions. Probation, most commonly used sanctions in the United States. Defendants likely to not commit another crime are granted probation. Public interest does not require the penalty required. Rehabilitation of the defendant does not require the penalty for the offense. Probation officers, before a person can be given probation, they will compile, evaluate, and present to the court a probation report, implement plans, assist offenders with employment, they track offenders, supervise probationers, maintain awareness of offenders' lives, conduct investigations, and supervision of the offenders. What sentence should be imposed again? Another form of sentence, we have fines, one of the oldest and most widely used form of punishment today. And we also have day fines. Restitution is another form of sentence. Offenders provide reparations to the victim for harm caused by the offense. Direct restitution and then symbolic restitution. Capital punishment, the death penalty. Under the 8th Amendment standard, we look at Foreman versus Georgia case of 1972, or the court ruled all existing death penalty laws invalid, and it led to the bifurcated trial. In other words, the jury, once somebody is found guilty, the jury has to also deliberate separately to see whether they're going to give that person a life sentence or a death penalty. Look at Gregg versus Georgia, another 1976 case from Georgia. Death penalty laws not always constitutional. Mandatory death penalty laws struck down, and the court ruled again that bifurcated process is required. Death penalty, we have about 3 different methods of execution in the United States. We have the lethal injection, where they use a cocktail of drugs to execute the prisoners. That's the most common one. Then we also have the electric shear, where the prisoner to be executed, they pass through some electrical voltage into their body to execute them. And then another one that most people are not familiar with is the third one, which being conducted mostly by the state of Utah. They give their prisoners like a couple of choices, whether they want to face the firing squad or they want to be executed using the lethal injection. And then you also, during the trial, death qualifies juries. In other words, the jury must also determine whether that person gets life imprisonment or death penalty. Narrowing death eligible cases. In other words, not every homicide requires a death penalty. It's limited to certain death eligible cases. Crime limitations, developmental limitations. Let's look at contemporary death penalty laws. Coker versus Georgia, another Georgia case, 1977. The court ruled that rape is not a grave enough offense to justify imposition of the death penalty. Let's look at the case of Atkins versus Virginia, 2002. The court ruled that convicted defendants with an IQ of 70 or less may not be executed. Death penalty again. Lengthy appeals and evolving standards. Automatic review, except for Arkansas, when somebody is given a death penalty, may file a writ of certiorari with the U.S. Supreme Court. Lengthy appellate process is involved before someone can be executed. In the case of appeals and evolving standards, in the case of Lockhart versus McCree, 1986, a death qualified juries have to be used. Hill versus McDonough in 2006, death row inmates may challenge in federal court a state's method of lethal injection. And ladies and gentlemen, that's the end of chapter 14. Now let's start chapter 15 of your textbook. Chapter 15, Sentencing Decision. Welcome back to class. Learning objectives. Define the concept of normal crimes and indicate the two most important factors in determining normal penalties. Distinguish between the concepts of sentencing disparities and discrimination. Explain how scholars approach the issue of racial discrimination differently than the general public and the implications these differing approaches have for the conclusions reached. Indicate why the offender-victim dyad is important in studies of racial discrimination in capital punishment. List the two major factors related to disparities and sentencing. Recognize the main objectives of changes in sentencing structure beginning in the late 1960s and the major consequences of these changes. Outline how the U.S. Supreme Court has limited state sentencing guidelines. Identify the most recent changes in how the U.S. Supreme Court has responded to federal sentencing guidelines. Explain the law in action perspective on researching the impact of mandatory minimum sentence. Courtroom work groups and sentencing decisions. Probation officers, supervision. They write pre-sentence investigation for offenders and for the court to go by. Recommendations include sentence, level of supervision, conditions of supervision, treatment plan, and community resources. Prosecutor, count or charge bargaining. Limit maximum penalty, that's their goal. They look at aggravating factors in the case, mitigating factors, and they recommend sentencing. Defense attorney, it's either they go to trial or a guilty plea. Sometimes they do what is called judge shopping. In other words, looking for a favorable judge that will hear their case, and they communicate with prosecutor. Emphasize circumstances favorable to the defendant. Judge. The judge, informal limits of courtroom work group, rely on the work group who has the most knowledge of the case. most experienced members of the courtroom team. Normal penalties and sentencing decision. Two-stage decision-making process. Probation versus incarceration, or if incarceration, and how long. Judges indicate sentencing is one of the most difficult aspects of the job. Normal penalties are guides and are not applied mechanically. It's based on the seriousness of offense, most important factor, harm harm that the victim suffered in the real offense is looked at. Prior record, second most important factor. Overall, longer prior record means longer sentence for the defendant. Length of time between offenses may also part of what the judges or the judge will be looking at. Aggravating or mitigating circumstances. In other words, under the aggravating, whether a weapon is used and injury to the victim. Under the mitigating circumstances, whether the defendant is a youth or lack of mental capacity, the role of the defendant in the offense, and social stability. Law in controversy, uncertainty, and public opinion. Sentencing is more art than science. Only mistakes resulting in harm will reach public attention. Differences in sentencing outcome. Let's look at that. Discrimination and disparity. Illegitimate influences on the sentencing process. Defendants' attributes are the primary focus. Imbalance versus discrimination. Mostly poor young minority males disproportionately represented in the criminal justice system. Legally relevant variables. Compare similar cases. And then we're looking at conflicting findings. Inconsistencies in sentencing resulting from the decision-making process. Most common has to do with the geography, judicial backgrounds, and attitude. The geography of justice, frequency of punishment varies by county and state. Amount of crime is looked at, police effectiveness, screening procedures, type of defendants also. If you live in southern part of the United States, sentencing is more harsher than anywhere else. Judges' background and attitudes. U.S. District Court judges appointed by the Democratic president more likely to find for the defendants. Perceptions of seriousness of crime. Let's look at discrimination and economic status. Poor person less likely to be released on bail. Poor less likely to hire private attorney. No release on bail and represented by court-appointed attorney means less likely to get probation and receive longer prison sentence. Conflicting studies indicate a complex relationship. Why have women increasingly been sentenced to prison? Because more of them are committing crimes now than men. Look at war on drugs. Are women sentenced more leniently than men? No, it's just more of them committing crime. We look at chivalry, evil woman, equal treatment. women commit less serious crime than men. Discrimination and race. African Americans punished more harshly than whites. Their sentences are longer. Even with extra legal factors, racial disparities still exist. Other research concludes race is not a factor. And then we also have sentencing guidelines that eliminate disparity. Inmates 18 to 20 years of age receive more lenient sentences. Younger women are treated with more leniency. And senior or older defendants get what we refer to as senior citizen discount. In other words, less time for their crime. Some of them might just even be sentenced to home confinement. Discrimination and capital punishment. Law is not biased. Discretion of criminal justice officials can be a conflicting result of research. Conclusion may be that discrimination is not overt, but has subtle and indirect effect. Offender-victim dyad. Black offender/white victim most likely to receive death penalty. Studies indicate racial discrimination in use of capital punishment in the South. Evidence of discrimination since Gregg case. Race found to be a significant factor. Evidence of no discrimination since Gregg. More sophisticated analysis revealed importance of legal factors. Prior relationship with the victim. Changing sentence structures. Let's look at laws and controversy. Reducing judicial discretion. Due process model advocates feared excessive discretion in sentencing. The crime control model advocates fair discretion, reduced crime control. Result of these two combined is the justice model of sentencing. Laws on the book. Structured sentencing. Determinate sentencing returns. Dissatisfaction with rehabilitation model. Specific sentence time. Abolition of parole vary widely by state. Presumptive sentencing. State sentencing guidelines. Continuum of voluntary to required use. Under that, we have adopted or seriously considered in over 21 states. Direct the judge a specific action to take, voluntary and presumptive. Federal sentencing guidelines. Most people see it as highly controversial. They see it as unduly harsh and failed to reduce disparity. Diverse impact also. Laws on the book. Mandatory minimum sentence. Here, offenders convicted of a certain offenses must be sentenced for a period of time not less than a specified period of years. We also have the 3 strike laws, and at the federal level, we have the truth in sentencing. Nullification by discretion. Sidestep by those who apply the law, such as police arrest, prosecutorial discretion, jury conviction, and judicial sentencing. Increasing the severity of the penalty. loss in controversy, negative side effect, time, effort, money being spent, and rigid inflexibility. That's the end of chapter 15.